Breaking news. Welcome to today's headlines. Untangling the court orders. Untangling the court orders. To my dear listeners from wherever you're listening from, please stay tuned as I read today's news. Many of us do not understand the difference between the various outcomes of substantive court actions or applications that litigants make during the course of proceedings, criminal cases, or appeals. Some common terms we hear are convicted, struck out, dismissed, set aside, discharged, and acquitted. Appeal allowed in part, and appeal dismissed, and do not fully know what they mean. Presently, there is the controversy about the recent outcome of Nnamdi Kanu's Court of Appeal case, charge number FHC ABJCR 383-2015, and appeal number CA ABJCR 625-2022, Nnamdi Kanu vs. Federal Republic of Nigeria, in which the Court of Appeal ordered that 1. This appeal succeeds and it is allowed. 2. The decision of Nyako of the Federal High Court, Abuja Division, delivered on the 8th day of April 2022, retaining count 1, 2, 3, 4, 5, 8, and 15 of the amended charges is set aside. 3. The said charges are accordingly terminated and struck out. The appellant is, in consequence, discharged. Kanu's counsel, Chief Mike Ozakome, San, maintains that he has been discharged with no criminal charges pending against him and should be released forthwith. On the other hand, the Attorney General of the Federation, Abubakar Malami, San, maintains that Kanu was discharged and not acquitted, and he has filed an appeal against the Court of Appeal decision to the Supreme Court. The term conviction is simply a court of competent jurisdiction finding a person guilty of a punishable offense having gone through trial. See the case of Muhammad versus Olawumi and ORS 1993-4, NWLR Part 287, page 254 and 287, Pau Gundare JSC, a sentence or resulting order, though distinct from a conviction, emanates from it. When an interlocutory application or action is struck out, it means that it was refused because it wasn't properly constituted. It was not heard on its merit, not a full trial. That is, that the court did not consider the substantive issues or determine the right of the parties in the application or suit. Based on a defect in issues of practice, procedure or form, the court refuses the application or matter and strike it out because of such defect. and not because it isn't meritorious. The litigant can therefore correct the defect and go back to the same court for the same application or matter. For instance, it could be that the proper parties to the actions are not before the court. See Oloriode vs. Oyebi, 1984, 1 SCNLR 390 at page 400 per Irikefe, JSC, later CJN. In Adesokan and ORS vs. Adetunji and ORS 1994, LPELR 52 SC per Ogundare JSC, the Apex Court held that when a court holds that a plaintiff has no local standing in respect of a claim, the proper order to make is to strike out such claim, not dismiss it. Since the court does not have the jurisdiction to hear such a matter, it follows that it cannot dismiss it on its merit. Having not had it, a matter that is struck out decides nothing as regards the matter in dispute, but merely gets rid of the pending action or application, leaving the plaintiff or applicant at liberty to begin de novo either in the same or subsequent suit. OKK vs. Modu 1996, 9 NWLR Part 470 page 131 at 137, C, JCA. On the other hand, dismissal means that a court entertained a properly constituted application or matter, heard and determined it on its merit, determined the right of the parties, and dismissed it. That is, refused it or discarded it. To my dear listeners, now I've come to the end of our today's news. Please do drop by our comment section and let us know what you've